Song is coming on. 3, 2, 1.
Good morning and welcome to our podcast called Law for Dropouts. I'm Munirah, and
I'm Hazim.
as you all know, this podcast was started by two law dropouts, aka me and Hazim, who seek to enlighten the public on topics pertaining to law.
Thanks for that introduction, Munirah. But yes, correct. Welcome, ladies and gentlemen. Today we have a very interesting topic to discuss, which is the concept of precedent. But before that, seeing as me and Munirah did drop out from law school, I believe that we are incapable and unqualified to explain this topic to you all. So this is exactly why we have a very special guest today on the show, our old friends from law school.
That's right, Hazim. Let's welcome the three judges, Yang Ahmad Arief, Tan Sri Hashry, Yang Ahmad Arief, Tan Sri Dato Mikhail, and Yang Ahmad Arief, Dato Arief himself.
Yeah, welcome guys. Welcome to the podcast.
Good morning, guys.
How's everyone doing?
Good morning, guys.
Hello and good morning to you guys too. Right, so how about we just cut to the chase, huh? Now, today we have a very interesting topic to discuss called precedent. And we have a few questions regarding the concept of precedent, and seeing that this topic relates very closely to you guys, we hope that the confusion that we and the rest have regarding precedent can be cleared out by the end of this podcast.
Exactly, Munirah. So without further ado, let's jump straight into it, guys. First question, what exactly is precedent?
So I'll answer this. Precedent is basically a court's decision that considered as authority for deciding subsequent cases involving identical or similar material facts or similar legal issues. Precedent is incorporated into the doctrine of stare decisis and required courts to apply legal reasoning or principle in the same manner to cases with the same material facts.
Exactly, Hashry. Oh, and this is Mikhail talking, by the way. Besides legislation, the principle of law can also be found from the previous decision of the court. However, only the decision made by the superior courts in Malaysia are considered as a source of law.
Oh, wow, interesting. I see. Well then, guys, what exactly are the superior courts in Malaysia?
Okay, Hazim. In Malaysia, we have the Federal Court, Court of Appeal, and High Court.
Thank you, Dato Arief. Could you explain to us how judicial precedent work as a source of law?
Okay, you see, when the material facts of the new case are the same with the material facts of the older cases, the ratio decidendum or the rational decision in the older case will be applied in the new case.
That is right, Dr. Arief. This is called the doctrine of stare decisis or the doctrine of binding precedent.
Interesting, Dr. Hashry. What is the doctrine of stare decisis, guys?
Okay, so that's a really good question, Azim. The literal definition of stare decisis is to stand by things decided. Whereas the technical definition is that in cases where the material facts are the same, a court is bound to follow the prior decision of a higher court.
That's true, Mikhail. A High Court is bound to follow the decisions of the Court of Appeal and Federal Court, but the Court of Appeal is bound to follow the decisions made by the Federal Court, and lastly, all the subordinate courts like magistrate and session courts are bound to follow the decisions of the Superior Court.
Okay, hold on. Earlier, you guys mentioned something called ratio decidendum, I guess? What is that exactly?
Okay, so in order for the doctrine of judicial precedent to work, it's important to identify the legal reasoning behind the decision. And when a judgment is delivered, a judge will set out their reasons for reaching a decision. The reason which form the basis of the decision is called ratio decidendi of the case. The term is Latin, which literally means the reason.
Okay, now besides ratio decidendi, obiter dicta is another important thing to note. It's a statement of law made in course of judgment which doesn't form the basis of decision. For example, the judge may go on to speculate his decision might have been if the material facts of the case had been different. This is an obiter dicta.
Okay, actually, obiter dicta isn't binding but may be of persuasive authority in later cases. In simpler words, it's basically the legal opinion of a judge. Sometimes a judge may say something like, "You have to be more careful next time," or "You should have performed your duty properly." These are all just opinions and doesn't count as a reason for the basis of decision.
Okay, thank you guys for that. So from what I could recall back in law school, I think there are different types of precedent, right?
That is absolutely right. There's original precedent, binding precedent, and persuasive precedent. Mikhail and Arief, care to explain what are these?
Oh, sure, Hashry, anything for my old friend. Okay, first, original precedent is just a case that is new and has never been in trial. So any rulings or decision made will create an original precedent. On the other hand, binding precedent is just the normal precedent, meaning a case will follow the precedent of an earlier case, even if the judge in the current case doesn't accept the legal principle. And for persuasive precedent, I think I'll let Arief explain about it.
Okay, so persuasive precedent, like as Mikhail just said, which is the precedent that's useful to a case. It's not mandatory for judges to apply persuasive precedent since it isn't binding, but it may persuade a judge if he accepts the legal principle.
Okay, that's a very interesting breakdown on the divisions of precedent. But I'm slightly curious, guys. Could there actually be a situation or a case where precedents aren't used or maybe avoided entirely?
Actually, Hazim, there are situations where precedent is avoided.
Oh, situations, plural. So like a lot of cases. What causes a case to avoid precedent?
Well, for one, there's precedent made per inquirium. Per inquirium literally means through lack of care. So these precedents are obviously avoided.
Yeah, that's true, Ashri. And besides that, if two cases don't share the same material facts, we also can't apply a precedent there.
And in addition to that, we also have what's called reversing and overruling. Reversing is when a higher court overturns a decision of a lower court in the same case, and overruling is when a court chooses to disagree with the decision made in the later case. So the lower court's decision is in use, and the court's decision made years ago may be overruled by a court's decision made recently.
All right, guys, those are some very interesting facts and explanations regarding how certain situations don't require precedents or precedents may be avoided entirely. So moving on to our very last question of today, are there any pros and cons to precedent? I mean, if there are any.
Of course, there are pros and cons to precedent. I mean, in everything you do in life, there's always pros and cons. After all, there's no perfect system. So the pros for this is that first, it promotes equal treatment of law to the same subject matter. Second, there's certainty, like how parties can assume that all cases will be treated the same by the court, rather than judges making their own decisions every time, which no one can predict.
See, so those are the pros. However, what about the cons? How about we have Mikhail to explain this.
The cons. Okay, well, for one, it is rigid. Judicial precedent forces judge to stand by a previous decision. This encourages bad judicial decision to perpetuate for a long time before a successful appeal is heard to overrule, setting a new precedent. Thus, a law can remain in place for a long time, even if it is outdated, as change requires a case to come to a higher appeal court before a new law can come about.
Okay, on top of what Mikhail just said, there's also uncertainty in the sense of that the result of a court case can be uncertain until the final judgment is made. Some judges may be unwilling to depart from a precedent to make a change in law.
Oh, okay. So that was a very enlightening session we had. And I really appreciate the conversation we had regarding the concept of precedent. Guys, thank you so much for sitting down with us today to discuss the concept of precedent.
Yeah, honestly, guys, we really appreciate you guys taking the time away from your work and busy lives to come down and enlighten us all on this interesting concept of precedent.
No worries, guys.
Yeah.
Okay, no
Anytime,
worries, man.
Do invite us again.
All right, sure. All right then, guys, ladies and gentlemen, so I hope all of your questions and confusions regarding this very intriguing concept of precedent in courts of justice have been answered and cleared out. Until next time, people, see you guys later.
Goodbye, everyone. Make sure to stay tuned to our new episodes.